Let's get more reaction now. I am joined by Bosa leader, Mmusi Maimane. Mr. Maimane, good to have you on the program this afternoon. What were your immediate thoughts on the High Court's decision to dismiss the MK Party's urgent application to indeed stop the JSC interviews from going ahead, especially in light of Judge Wilson's ruling?
Good afternoon, and good afternoon, fellow South Africans. First and foremost, I uphold the absolute principle of the separation of powers. And my sense was that if the courts are being tasked with the duty of setting a timetable for committees that are an extension of Parliament, then it says that Parliament's own internal workings are failing. And what we cannot be sitting here trying to establish is that every matter that is parliamentary ends up in court. That is the original challenge that we're faced up to, is that we've got to be able to not only have individuals who are ethical, who you can't be impeached in one section of the state or one arm of the state and end up serving in another. We need to be able to establish those rules properly so that we don't have to deal with the challenge that is being emerging now. That's on the first instance. On the second, I don't hold any particular issue on the person of Judge Hlophe himself. I certainly think that the MK Party could designate any other individual it so chooses to the respective body. It is far more important when you look at it from a South African's perspective, which is to say the functioning of the courts is urgent. If you have, as we sit here today, a delay in the Gauteng North High Court of nearly up to 4 years before you can get a court date, further delays in appointing judges means that the very exercise of justice becomes delayed and in certain instances, just thanks to time, becomes denied. So therefore, we need to deal with the urgency of fixing our judicial systems at that level. And then lastly, I think the rules must apply to everybody. The Minister of Justice herself is facing some serious allegations on this issue of VBS. And therefore, I do think that even though a court has not found against her, that it must be ethical conduct, that she should not be part of the proceedings, because ultimately you want your Ministry of Justice and the judges it appoints to be without scrutiny, that our politics aren't, our governance system is not about politics, but really about the people. And therefore, we need to free up that the proceedings must take place tomorrow with individuals above ethical standards to be able to appoint judges.
But zooming into these proceedings, how do you interpret the court's finding that the JSC acted rationally in refusing the MK Party, or at least their candidate, from attending these proceedings, or the request to postpone the interviews? And what implications does this have for judicial accountability?
No, I certainly think that, as I stated earlier, the earlier question is whether someone can be impeached in another arm of the state and serve is a challenge. But furthermore, I do think that you cannot in any way, unless there are other circumstantial evidence that can be presented about what the delay would best serve, I certainly don't think that it would be material in the long run. Therefore, I do think that it is incumbent upon the MK Party to be able to produce a candidate who will serve in the proceedings, and we can proceed. But I think Parliament must take an active role here. We, the people of South Africa, all we want is judges that are appointed fairly, without settling of scores, that the system is allowing itself to say, let's capacitate our courts so that we get justice. But any further delays, etc., play into the realm of politics. They undermine Parliament, and when it's said and done, it undermines the very exercise of justice.
But how significant do you think the court's ruling is for the overall public perception of the judiciary, especially concerning the MK Party's attempts to influence these proceedings or the processes as well?
Yeah, look, I think certainly what we cannot do is end up in a space where we take political considerations in making law. The law is the law, and the principle of the separation of powers is fundamental in this instance. Courts cannot set the timetable. Parliament does that. And therefore, having said all of that, I certainly think that it gives a perception that says that the judiciary is doing its own duty. And of course, part of the judgment says that there are other matters about Judge Hlophe's own qualification for candidacy that still must be interrogated. And I look forward to hearing the judgment on that particular application. But as things stand at the moment, I certainly think that it is possible that another candidate can be found that is from the MK party, because there are members of parliament there, and we can proceed in this regard. Because at the end of the day, what you don't want to do is create the impression that a candidate who was making an application was favored or not favored, thanks to the nature of how the panel was constituted. So as South Africans, what we desire and want is that we want a panel of interviewers to be of such a standard that when you look at them and the interview process, they will then ultimately appoint people who are above ethicals, who are ethical, and who are able to say to themselves, they're not just ordinary members of parliament, but these are people who are trusted with the duty of appointing what is a very fundamental function in our country, which is the law and the rule of law, and ultimately the application of justice.
But given that the MK party plans to challenge this ruling, what do you believe should be the next steps, especially for political parties in light of this ongoing legal battle that we're seeing play out here?
Yeah, let's allow the courts to hear whether the suitability of a judge, or of an impeached judge, is able to serve to select the next set of judges. That is but one question that the law must finalize on. But the point I really want to make is to say, we must, if the qualifications in the Constitution as to who qualifies to be a member of parliament, that's fairly laissez-faire in approach. They open themselves up for anybody to be able to be a member of parliament, so long as you have not been sequestrated, you are of the right mind, and you are a voting citizen of the age of 18. Now, what we are learning in our new democracy of only 30 years old is that actually those may not be sufficient. So we need to be able to expand them further and educate voters that when you vote for someone, that let's elect someone who's able to fulfill ethical standards, various qualifications, that those are not sufficient because they are going to create more and more of these challenges. It must extend to the fact that people charged with corruption can't just be serving in parliament, because you can't ask lawbreakers to be lawmakers. And that is applicable on state capture matters. It's applicable on VBS. It is applicable on being impeached in other sections of the state. So I really do think that the next steps ought to be, in essence, an ad hoc committee that looks at what the suitability of a member of parliament ought to be, for parliament to be able to establish its own rules going forward, so that we through the process of lawmaking, correct these anomalies. Otherwise, we're going to end up in court continuously.
But in your opinion, Mr. Maimane, what reforms, if any, are necessary within the JSC or even the broader judiciary to prevent similar controversy from arising in future?
Exactly that. It's about ensuring that Parliament drafts laws as to what are the qualifying applicants for the JSC. So Parliament must do its duty there. But I think as far as the lawmaking process and the judges, the nomination and the Chief Justice, in how that matter is composed, I think the JSC has served us well. We've never had such challenges. Therefore, I do think what we need to fix for is to make sure that each of the people who serve on that meet a particular criteria, and only Parliament can be able to do that. No court is able to prescribe to Parliament what it cannot do, what it can, who it can deploy into that space. So I do think that this actually is a failure of Parliament, and if we don't fix that, I promise you it is true in this instance, it will be true in many other decisions of Parliament that will be deemed irrational on the basis of people who are being serving on particular structures such as this one.